Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. Don't forget, comment, like, and subscribe. And if you love this channel, please become a member. Welcome, everybody. We are dual living today. I have Karen Reed in queue. We are waiting for the court to come in, and we have been live with the Georgia versus Faust all day today. We've gone through day one, and we're in day two, and tomorrow will be day three. So we're catching up. So I've got two lives going. We are also waiting for the Taylor Robinson court hearing to begin. Of course, all the courts are running behind. Not surprising. So let me get the Karen Reed up here and showing. Boop, that's the way it's going to be right now for the Karen Reed. So let me go ahead and get back off. Let me get this up and big. How is everybody doing today? Y'all. I've had a wonderful show last night. Thanks to my mods. We did a great, surprising show. I'm getting you up here, Miss Diane. Are you ready to come on? Okay, let me get you up here. Hold on. Get the interpreter roll up. And I can't hear you, boo. Where are you? There you go. Right now, I'm not too worried about it. It just creates a beautiful halo for you, boo. Yes. So, why don't we do this? I'm going to have you interpret a little bit for me. I'm going to talk a little bit, if you don't mind. The Karen Reed wrongful death lawsuit. Right today, they're expected to be in court this afternoon. Hearing was filed by John O'Keefe's family. Reed was acquitted for second-degree redrum. Uh-oh, here we go. We got video, so let me get the video up in this. What is acquitted? Oh, not guilty. I'm going to take that down. I didn't know comments was up. Let me get that down. Sorry about that. What am I doing? Oh, come on. Share screen. I got too many things up and going, y'all. I got 3 courts going. Okay. Diane, I'm going to have you interpreting this, and then I'm going to be mute. I'll be talking over at the Karen Reed. Oh, God, the audio sucks. I'm sorry. I'll fix it. Okay, we're back over at the Karen Reed. I don't know why the families called this particular motion hearing, but we will see soon enough. They should have started already. The sound over there is bad, y'all. Okay, guys, so over here in the Karen Reed, we are... Okay, so let me see what I can find out on the hearing today on Karen Reed. Find out why they have filed. Dang audio's bad over there. I'm sorry, guys. I've done the best I can. Hello, everybody. Thank you all for hopping in. Don't forget to do the I likes, I shared, all that good stuff. I got a lot to do. Hold on. Karen Reed. Don't forget to do the I liked, I shared in the Karen Read, please, so I can get you in. I'm getting that signed up, and then I'll talk to you. Okay, so I got that done. Okay, so here's what's happening in today's civil trial involving Karen Read. The hearing is a wrongful death lawsuit, not a criminal trial. And today's hearing is scheduled for noon their time. Our time is focused on the status and the procedural matters in the civil case, such as the discovery, and all discovery will proceed, and the evidence that will be exchanged between the parties, its disclosure, its future deadlines and trial dates. So this is kind of like a planning hearing for the roadmap for the rest of this case. According to recent posts about today's hearing, Read is expected to appear visually or in court this afternoon. The judge hears updates from both sides. So that's what we're going to be. Today, we expect the updates on discovery or motions, possibly set or adjust the deadlines related to the evidence exchanging between the prosecution and the defense, and possibly will address any requests that either party to narrow or modify issues before the trial, before the courts. That is where we are on that. So I'm trying to also fix, the other court has horrible audio. All right, guys. So I'm going to go ahead and put on the music and put the court feed up, and we'll be right back, y'all. I gotta move the screen. Hold on.
My role is to cover the hearing that we have going on this afternoon. The decorum and the EMC as well.
There we go. All right, guys, we're all good. I'll put the music up until they come on. What happens when you bounce lives? Y'all, I have to say, y'all, I am absolutely floored over the fact that they're still going on about lip reading. Miss Diane can raise her hand. You cannot lip read from the side. You cannot lip read if there's a hand half in front of your face or a face in front of your face, and you can't lip read a still shot. And they talk about these lip reader apps. Y'all, you can ask Miss Diane. They suck. Mary and Barry look the same. %30 of an average lip reader is caught in lip reading. Now, if you're really good, really good, really good, then you might be able to get 40%. A lot of lip reading is not just about reading lips. It's also more conceptual in context and understanding and knowing what the context is. That's what people don't understand. It is not necessarily every word on the mouth. That is not how it works, y'all. It doesn't work that way. And so they're sitting here. Why are you hyper focusing on lip reading and this crap when you need to be focusing more on your client? You need to be focusing on what's happening in the case itself. Spending all this energy and time over lip reading to me is bull crap. Sue Thomas. Well, and I will tell you that even she said, this is not an exact science. I am not always right. I can give a lot of information, but I am not always right. And a lot of times she already had an idea what they were talking about. If I walk into a conversation and I'm trying to lip read and I have no idea what the topic is, I'm going to get it all messed up because goat and boat and chote and dote and all these words look the same. Yes, this here is the guy who killed Kirk. It's the Kirk trial and their pre-trial motions. Yeah, he's the one that shot Kirk. By the way, but is it true that if you've got a handful of possible words, you could then use AI to figure out what they're saying? For instance, hat, rat, bat. AI can guess that right. No. I mean, yes, you can guess, but it's 25% if you got a hat, bat, rat, and cat. 1 out of 25%, you're going to be right. And then what AI does is it looks at the conversation and it plugs it in. That's what we do. AI is not any better than someone who's deaf who lip reads all day long. Now, I can't lip read if you talk like this. I can't lip read if it's fuzzy. I can't lip read if you're like this. I mean, it has to be straight on, just like this. And they have to be able to pronunciate, no mustache. They have to be able to pronunciate their words. They need to be speaking clearly and about this pace. They can't be talking about like this and then want me to figure out what the hell they're saying. And they can't be doing this. They can't be doing this. They can't be doing this. I mean, it is such, people have no idea. And they go, well, how do you lip read all day? Well, my hearing aids do give me minimal sound. So I have minimal sound. So I have consonances and things that go with sounds. And I can, once again, guess. I have totally messed it up and totally misconstrued the entire conversation. So with that, this right here to me is so irritating. Okay, we got to get back to this, but I just want people to understand what this lawyer's talking about. He's blowing out his ass. Okay, guys, I don't know why we do not have a feed. Sorry, you may have heard my description over there. I thought I had it turned off. We've been glitching all day. Truth be told, we've been glitchy all day. So they were supposed to go live at 2. Let me see if they're on. Hold on. Let me get them. Let me get the video up.
a little unreasonable?
I certainly would, Your Honor. What's been happening in this case, every time we serve a deposition, we serve a subpoena, we either are ignored by the recipient of the subpoena, as happened with Sergeant Good, happened with Mr. Proctor, happened with, at first, the Boston Police Department. Then we're presented with objections and a refusal to produce documents. We try to confer. These are government entities in large part that we're discussing right now. And it takes time to even get people on the phone. We get them on the phone. There's continued
Resolve.
July to August. And then, as I said, we followed up with a second subpoena. Their counsel, additional documents that we had been under the impression they didn't have, but now I believe they may actually have. So I'm in the process of a 9C conference with their counsel to determine if they will produce these additional documents that they should produce from our perspective.
When did the subpoena to the Boston Police Department go out?
Roughly the same time. So the first subpoenas we sent all around the same time was the town of Canton, the Massachusetts State Police, Michael Proctor, and the Boston Police Department. Those were all July to August. And then, as I said, we followed up with a second subpoena to Mr. Proctor, approximately September of 2025.
Would you agree that 8 months to resolve issues from subpoenas might be a little unreasonable?
I certainly would, Your Honor, but here's what's been happening in this case. Every time we serve a deposition, we serve a subpoena, we either are ignored by the recipient of the subpoena, as happened with Sergeant Good, happened with Mr. Proctor, happened with, at first, the Boston Police Department. Then we're presented with objections and a refusal to produce documents. We try to confer. These are government entities in large part that we're discussing right now. And it takes time to even get people on the phone. We get them on the phone. There's continued refusal to produce documents. We attempt to confer, as we're required to under 9C, to try and get documents without burdening the court with motions to compel. We then, in some instances, for example, the district attorney's office, just as one example, they have a set of documents that were taken off of Mr. Proctor's personal cell phone and then identified by the district attorney's office in the Commonwealth, documents that may be evidence of bias. They did that pursuant to a court order in other criminal cases. They then returned that phone to Mr. Proctor. We tried to get the phone and the same data from Mr. Proctor pursuant to subpoena because the district attorney's office told us they wouldn't give it to us because it had to come from him directly. As it turns out, that phone, after it was provided back to Mr. Proctor from the district attorney's office, in the short period of time between that and when he hired his present counsel, he apparently lost that phone. So now we can't obtain those documents from Mr. Proctor. So we had to go back to the district attorney's office and tell the district attorney's office we need it from them. I then engaged for 2.5 months negotiating an agreement with the district attorney's office, which would only give us these relevant documents, despite the civil rules, would only give them to us with onerous restrictions that are unusual if never occur in civil cases like this. But we agreed to that because we need to get the documents. So I 100% agree with you. When we've sent out subpoenas, we have not gotten the responses that we should have gotten under the rules and the law. But we've had to put in a lot of extra time and effort and resources to getting these entities to produce documents. The state police still haven't produced documents. I was under the impression they'd been reviewing them for months, just found out from their counsel that they had made little to no progress, and I needed to again threaten a motion to compel in order for them to agree to produce, to do what they have to do. So I agree with you, Your Honor. We shouldn't have to wait that long.
But here we are in February and we're not any further along. I detect a little frustration from you, Attorney Rosenberg, but why don't you utilize the court to maybe relieve that frustration? If you have issues that you need to bring in front of the court as far as a motion to compel, let's get them filed. This case This
Can I
case
just be clear?
It needs to start moving along.
Well, I need to be clear with Your Honor, and I'm hearing you don't want us to confer with these parties and continue to drag out those conversations. The rules, I believe, would require me to do that, and I can't just come into court asking for a motion. But if you'd prefer us to handle it this way when we get non-compliance from a subpoena recipient, I'm happy to do that. I just am sensitive to the requirements of 9C.
I'm not suggesting you ignore any of the rules. I'm suggesting you avail yourself of the opportunity to use them. And I'm simply suggesting that the length of time that it has taken to resolve issues that shouldn't really be issues appears to me to be excessive. So we have to figure out a way to bring them to a head.
Well, I agree with you, Your Honor. It's just, it's excessive from the recipients of the subpoenas. We're certainly not delaying anything. We've been demanding documents since July, and we've been out there taking discovery and trying to move the case along, which is what we intend to continue to do. So as soon as I have a situation where the recipient of a subpoena is not engaging in good faith conference under 9C, we've been filing motions, and we've had, I believe, 3 or 4 before, Your Honor. Then the parties who have received the subpoenas seem to all of a sudden be more willing to comply just before we have hearings with the court. And so we are using those tools, and we'll continue to do so.
Anything else?
Not for me, Your Honor.
Okay, so why don't we all plan to get together next Thursday at 4 o'clock in the same fashion? And Attorney Diller can report on his success or lack of success in seeking to access the documents. And it'll give you and Attorney Diller a further opportunity to talk about his concerns about categorization or identification of the documents that are produced. And then I'd ask all the parties to submit at this point in time the intended depositions. And I understand that may change, but I want to know who people intend on deposing. Is there anyone that can't make it next Thursday at 4 o'clock? Hearing no response, we'll see everyone next Thursday. Thanks very much.
Your Honor, I have a question though about the request for the intended depositions. Are you looking for that to be a formal written disclosure, or is that something that we could show you in camera so as not to make public all the parties that we intend to depose?
You can share it to me in whatever fashion you want to.
Okay, thank you, Your Honor.
All right. Anyone else have any questions? Okay, thanks very much. We'll see everyone next Thursday.
Thank you, Your Honor.
Okay, so for the record, this matter is continued to February 12th, 2026 at 4 p.m. for further status, and that hearing will be held via Zoom.
And Attorney Rosenberg, still, because I want to have a clear record here, please, as I indicated earlier, provide the court with a copy of whatever you produce to Attorney Diller.
Okay, it'll come from Mr. Maravellis and Mr. Bell, my co-counsel. The production came from their office.
All right. Thank you.
Your Honor,
Thank you.
Your Honor,
Yes, sir.
with respect to production, who would you like me to coordinate with? Because our office will need to coordinate with somebody from the court with respect to e-discovery. We cannot just send you an email. It's a much more complex process that we've been involved in. We have an e-discovery vendor, and we would need somebody on the court side to have it, to be able to receive it. Otherwise, we can't just, you will not be able to receive it just via email. You'll need some type of technical capabilities to receive the actual documents. So we're happy to coordinate with somebody with the court if there's somebody you'd like to put us in touch with.
You can start with Assistant Clerk Donovan.
Okay.
Okay?
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you all.
Nothing burger. It was a great big nothing burger, guys. I am so sorry. I have 2 lives going at once, so it's really hard for me to hear any details. So what I'm going to do is I will rewatch that later and come back and give you my opinions. But thank you so much for joining. Hop on over to our other live if you wish. We are now currently watching the Tyler Robinson hearing. It's gotten a little interesting. I'm really surprised at some of the crap that's going on. I'll be honest. I'm trying to see if I can do hold on, I'm trying to do something with y'all. Customize. Redirect this. Save. Okay, so y'all are going to redirect back over there. I will go and do a short that will encompass everything that we did today. It's been a lot, so keep your eye out for the short. Please comment, like, and subscribe on the channel, and we will see you at the other live. See you in a minute. Have fun. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.